Hi, good afternoon, everyone. Thank you very much for joining us today. My name is Ayumi Fukuhara. I'm an investigation partner at Nagashima no Tsunematsu, and I'll be a moderator of this session. So this session will be the last session today. And this session focuses on human rights and supply chain risk management, and especially how companies can move from just compliance to practical implementation based on the recent developments and the regulatory changes across the world. So before we start, may I ask each of the panelists to briefly introduce your background and the specialization? So Naoko-san, could you start?
Sure. First of all, I'd like to thank Daisuke and the organizers for putting this conference together and having me today. My name is Naoko Matsuzaki. I'm with KPMG Forensics and Risk Advisory. I actually come from a legal background, working as in-house counsel at a Japanese conglomerate for 15 plus years. Initially starting from the transaction side, doing contract negotiations, and then switching over to the litigation side or the defense side, doing alleged corporate misconduct investigations, regulatory compliance, and subsequent litigation, et cetera. And approximately 10 years ago, switched to the world of consulting, advising clients mitigate corporate misconduct.
Hi, everyone. I also want to say thank you to Daisuke for organizing, and thanks to everyone for being here today. It's really a privilege. My name is Mari Grace. I'm a litigation partner at Davis Polk, which is a global law firm. I focus on white-collar crime enforcement and compliance, as well as civil litigation, which includes securities litigation, M&A-related litigation, and also antitrust litigation and advisory work. I think I'm here because I used to be a social worker before I was a lawyer, and so my whole life was about human rights, and this is my way to sort of bridge the gap.
Good afternoon, everyone. My name is Yuta Sugie, a partner at Nagashima Oren Tsunematsu. I started my career about 10 years ago at Nagashima, and I have been focusing on white-collar investigation, including both government-facing investigation and internal investigation, as well as providing clients with advice on improvement of compliance programs. So thank you for having me today, and it's great to be here as one of the panelists, and look forward to discussion today.
Thank you. So let me start with the recent changes, because we are seeing important developments and also changes in sustainability disclosure or regulatory trends and enforcement. So this is a question to Naoko-san, but what are the key changes you are seeing in ESG context globally first?
Thank you for the question. So maybe just to start off, to level set, I might want to give a broad overview at a high level around ESG/sustainability. So up until 2024, at least I understood that as a global trend, we were somewhat moving to one direction, where governments and businesses were moving more towards regulating and strengthening ESG sustainability initiatives and disclosures. I think the EU was one of the leaders in promoting this movement. Going in chronological order, back in 2022, there was this CSRD, which is a reporting directive obligating companies to disclose, report ESG-related information. And then in 2024, there was CSDDD, which is a due diligence directive obligating companies to identify risks, prevent and mitigate, and monitor the process, and which included human rights due diligence and also measuring environmental impacts that the company might have in their operations of their entire supply chain. And then also in 2024, there was this EU forced labor regulation that was more focused on, again, the human rights perspective that we will be talking about, which prohibits products made with forced labor to enter into the EU market. So this was not a reporting obligation or a due diligence obligation, but it was more on ensuring that your supply chain is clean, which obviously need to understand your own supply chain from a human rights perspective. However, I think that there was this turning point in 2025 where this direction was somewhat pushed back a little bit, where there was this omnibus package. For those of you who are familiar in this space might have heard of this word, which is more of simplifying or lessening the burden onto companies, where the CSRD, the reporting directive, and the CSDDD, the due diligence directive, got more narrower in scope on which companies are subject to those obligations, and also the disclosure, the broadness became so much narrower. However, the EU forced labor piece, the one that prohibits forced labor products to enter into the EU market, that has not been affected by the omnibus package. So that is still planned to be enforceable in 2027.
Thank you very much, Naoko-san. So I understand the CSRD and the CSDDD could be applied to a Japanese company as well if the sales revenue thresholds are met, and also forced labor regulation will be applied to the Japanese companies regardless of the size or sector. And so it will impact the Japanese company as well. But on the other hand, how are the movements of Japanese government?
Japan is actually taking a unique position, in my personal opinion, where it has been touched upon in earlier panels about this like corporate culture and the harmonization and the culture of consensus. And maybe that's part of why it's like this, but Japan is actually slowly but steadily and gradually moving towards sustainability-oriented regulation and corporate practice. So for those of you who might know, recently, well, a year ago, in 2025, there was this SSBJ, which is the Sustainability Standards Board of Japan, finalized this incremental rollout of mandatory disclosure about sustainability information. So that will be gradually be applied to companies starting for the most large organizations, and then gradually would also require third-party assurance, which obviously a firm like KPMG would be one of those third parties who would be assuring the disclosure or reporting. Also, there has been some gradual, again, slow but gradual, and it's soft law, so it's not mandatory, but still there's this stewardship code and the corporate governance code, who was initially, dates back 10 years ago, but has been amended over time. And now there's, and those two actually work hand in hand, because the stewardship code gives guidance to the institutional investors, whereas the corporate governance code regulates the corporates, the companies. And those two work together to improve corporate sustainability, accountability, and ESG integration into the Japanese capital market.
Thank you very much, Naoko-san. And it should be covered later by Mario Suge-san, but the U.S. is taking a different action towards anti-DEI. So next question will be to Suge-san, but this kind of various movement raises a question of how Japanese companies manage the different requirements across jurisdictions. So what are your thoughts?
Yeah, thank you, Fukuhara-san. And I think Naoko-san provided an excellent overview of the trends in each jurisdiction. And as Naoko-san mentioned, just to recap, Japan is expanding gradually the scope of companies that are subject to sustainability disclosure. And in addition, the Japanese standards is now trying to require companies to make the content of disclosure more specific and detailed. In EU, the omnibus rule is trying to simplify disclosures and narrow disclosure. But mandatory sustainability disclosure in EU remain in place, at least to some extent. And on the other hand, in the United States, and Mari, you can talk about it, talk about the United States, and you are in a better position than myself. And my understanding is that the United States ESG-related initiatives are losing its momentum.
That is
under
accurate.
The Trump administration. So from the perspectives of lawyer who advises Japanese corporations operating globally, companies are now required to be up to speed on developments in various jurisdictions and comply with the varying disclosure requirements in each jurisdiction. And to that end, it's critical not only to better understand disclosure requirements and reporting requirements and differences across jurisdictions, but also to centralize sustainability, ESG-related data and information within the company group so that the companies can ensure traceability and accuracy of disclosure. And sometimes companies may make strategic decisions for striking balance between the disclosure requirement in EU and requirement in Japan and requirements in the United States. So anti-DEI and illegal DEI is one of the good examples. And actually, Mari and myself collaborated for a Japanese financial institution, and we advise on how to address differences in Japanese, EU requirements, and United States requirements. As some of you know, the anti-DEI policy under the Trump administration is something like discriminatory treatment under the name of DEI is now illegal. And my understanding is that the government gradually started enforcement against companies, and the United States authorities started leverage the anti-DEI policies when engaging with corporation in terms of a merger clearance or government negotiation. And so the bottom line is that Japanese companies does not have to change its DEI initiatives drastically, but I think it's prudent for companies to pay close attention to information provided on the company's website and its disclosure document in terms of DEI. So that kind of balance the Japanese companies are now required to take and strike. So sometimes this may be a strategic event and somewhat technical decision, but companies need to pay close attention to varying disclosure requirements and take a position how to address these varying requirements.
Can I add just one
Yeah,
quick
sure.
thing? So I agree with all of what was just explained. Maybe just two quick counterpoints. So one, I think it's totally right that the federal government in the U.S. has definitely moved in one direction. But the U.S. has 50 states, some of which are fairly powerful and have different political views. And so something to keep in mind if you're operating in the U.S. is if you have operations in New York or California, for example, they have state attorney general's offices and their own governors that have different viewpoints. And so sometimes you can have disclosure requirements in particular states that are very onerous, that are going to be very different from the federal requirements. And we also really like litigation in the United States. And so there's a whole private plaintiffs bar, a group of lawyers who, like to bring lawsuits to put political pressure on companies, whether that's through class actions, whether it's through finding shareholders to apply pressure through proxy contests and the like. So that's something too to keep in mind, because the interests of those groups are sometimes different from, what the president or the federal government's overall view will be.
Thanks. I have a quick question. So if the U.S. companies have several offices in the different states, do they have to change the disclosure depending on the...
Sometimes they do. And California is a great example because California recently put out all of these climate disclosure regulations. And so companies are struggling because let's say you're an oil and gas company or you're a defense contractor and you have some operations in California, or you have employees there, or you manufacture a particular part there, and you're used to operating in Texas and not needing to provide these disclosures, and then suddenly you're supposed to put on your website and in your SEC filings what your greenhouse gas emissions are. It's really hard for companies to sort of grapple with that. But yes, I think if you're operating in different states, then to be safe, you do want to make sure that you're checking what all of those states' disclosure laws are.
Thank you. And as you already covered, we also see some mixed signals in the United States related to the enforcement of the forced labor. So could you elaborate that point?
Sure. So maybe just to take a step back, so forced labor is often talked about as a human rights issue. I think in the U.S., especially right now, it is also viewed as an economic policy issue. And so I think that's the lens through which it's important to think about these things right now. So for example, people were really focused on the UFLPA, the Uyghur Forced Labor Prevention Act. And basically that was put in place under the Biden administration. And I'm simplifying, but basically the presumption is that anything that's produced or manufactured from the Xinjiang region in China that's imported into the United States, the presumption is that it's the result of forced labor. And then companies, the burden is on them to basically prove to the US government that it was not the product of forced labor, which is a very hard thing to prove. It's like, and you have to show it by clear and convincing evidence. So that was a couple of years ago. I think the Biden administration did a lot to enforce that law. I think to your point about whether there have been changes, I think over the last year or so, people have seen a drop-off in enforcement, both in terms of the number of shipments that have been stopped, and I'll go into a detail on that in a moment, but also the value of shipments. So if you look at, I think the last year of the Biden administration, it was like $1.7 billion of goods were stopped based on UFLPA violations or supposed violations. And I think in 2025, it was like $170 million of value, so like 1/10. It's interesting because Customs and Border Protection actually changed the definition of what a shipment is. So if you look at the statistics, it's the same number of shipments that have been stopped year to year. But now, and again, I'll just give like a simple example. Previously, like in 2024, if a cargo ship came into the US and it had 3 different products that were all suspected of being, the product of forced labor. You had apparel, you had steel, you had electronic goods or parts. That would still count as one shipment because it was on one ship. Now they're going to count that as 3 because it's 3 different products. So if you look at the numbers, they're the same, but it's because they're calculating the numbers differently. So there's that, there's the value of the goods. And then the third is there's an entity list that's part of the UFLPA. So there's, sort of a list of companies. And, if you have a good that's imported and the company that produced it is on that list, then the presumption is that it was a product of forced labor. And no new companies have been added to that list over the last year. So I think those are the reasons why people think there hasn't been as much enforcement during this administration. But I will say the caveat to all of this, and again, going back to the point about economic policy, is there is a focus on forced labor in some areas. So the administration's currently negotiating various trade agreements with different countries, especially in Southeast Asia. And there's been, press about the fact that those agreements are, expected to include terms that relate to forced labor. So that's one thing to pay attention to. And then the second thing is the U.S. Trade Representative recently announced that they're investigating 60 different trade partners of the United States, so basically 60 different countries, not for forced labor goods that come into the U.S., but actually checking to see whether those countries have their own forced labor importation regulations and their enforcement of those regulations. And the theory behind that is if Japan, for example, is receiving goods, importing goods into Japan that are the product of forced labor, that somehow becomes a competition issue for the U.S. because you're able to produce things more cheaply than we can. And actually, Japan, surprisingly, is on that list. Japan usually is not on, these sorts of initiatives from the perspective of the United States. But there are many, sort of trade partners and allies of the U.S. that are on this list. So it's Japan, Brazil, Mexico, the EU, that all make an appearance there.
Thank you. So I understand that kind of initiative are motivated not by a kind of human rights or more of a political reasons. Is that correct?
Economics.
Thank you. That's clear. So let's now move from regulatory developments to more practical implementation. So many companies have already implemented human rights policies and suppliers code of conduct, but the real changes for the company is that what to do next. So this is a question to Naoko-san, but what is driving companies in Japan to take a more concrete action on human rights and supply chain issues?
So in my view, I see that it has the international factor and a domestic factor, or more of like an inner company inner factor. So starting from the international factor, I think obviously there's technological developments, digitalization, such as AI, that has been covered in our earlier session. And it's very apparent with all these like geopolitical tensions, such as tariffs, trade compliance, export control, etc., which forces companies to take action immediately. And the domestic or inner factor could be the raise of social awareness in our country. Maybe back 10, 20 years ago, all this something harassment type of issue was not that hot back in those days. But recently, I think people are becoming more and more sensitive about such human rights violation-ish conduct. Also, I think the consumer behavior is driving certain, purchasing behavior, or where people are more cautious about ethical sourcing or labor conditions, environmental impact that the product has. And also legislation is pushing that move. The English translation is Act on Improving Transactions with Specified Entrusted Business Operators, which is Toritekiho in Japanese, which used to be Shitaukeho, but now it's been amended, where it's trying to there's this like the power balance was that the suppliers or subcontractors were in a weaker position where they could not it was hard to contest on like, price reduction pressure, etc. But now we're trying to protect the economic unfairness in the supply chain. And if you're forced to supply products at a very low price, even with this inflation, then it could turn into a labor issue or a human rights issue where employees are forced to work long hours without being paid. So those, both the social awareness, like again, it might be like a soft law or peer pressure, so to speak, and the legislation itself, which is like pushing more for companies to act.
Thank you, Naoko-san. And I agree with that. And I feel that because it is widely known that the harassment is included in the human rights issues. So nowadays, a reputational risk of the harassment is now kind of increasing because in relation to that, the stakeholders, try to categorize it as a human rights issue rather than just guidelines or regulation.
Right. So there has been some cases that was widely public. And I think back maybe 10, 20 years ago, it might have been just considered, oh, it's an affair. Whereas now it's considered more of a human rights issue. So I think that's a very drastic change.
Thank you. So turning into the challenges in supplier management, Suge-san, what are the key challenges of the Japanese companies facing kind of monitoring their supplier effectively?
Yeah, thank you, Fukuhara-san. And so many of the risks and legislation that Naoko-san explained are all related to supply chain management and supply chain third-party management. And what that means is that it's critical for Japanese companies to put supply chain risk management system in practice within the company. And my sense is that many Japanese companies face challenges regarding how to effectively oversee their suppliers. And my sense is that some Japanese companies take measures such as setting contractual requirements that include compliance with relevant applicable laws and regulations and reporting obligations when finding any issues, and obligations to cooperate with audits by the companies, and distributing manuals or guidelines to suppliers, and obtaining written confirmation from suppliers saying that we are all complying with applicable laws and regulations. However, I think the companies appear to be struggling to monitor how suppliers' compliance programs are designed and operated effectively. And due to lack of resources or insufficient communication with suppliers, companies have been unable to obtain information required to analyze supply chain risks and to be comfortable with suppliers' compliance programs. So as the second panel discussed, of course, one of the important tools is AI, and it's a viable option for companies to install agentic AI to analyze its supply chain risks and supply chain mapping. And if companies still feel difficult to conduct monitoring of its suppliers on their own, then they may want to consider consulting with external lawyers or compliance consultant and have them analyze companies' supply chain risks and test suppliers' compliance programs by taking so-called risk-based approach. So those kind of approaches are required for a Japanese company to take right now. But I'd like to invite other thoughts how to practically address supply chain risk management.
So maybe you, Mari, maybe you want to add a point from your
I agree with all of that. I think the one maybe two things that people are focusing on a little bit more now are sort of the last 2 points that you raised. First, enhanced due diligence on particular higher risk third parties. So like actually going and visiting certain suppliers, understanding what their own due diligence programs look like, which you just, you can't, if you're a huge international company, you cannot do that with every single third party. It's impossible. But really identifying the ones that you either know operate in higher risk jurisdictions or provide products that are more likely to, be manufactured in a high risk jurisdiction, or if it's a supplier who you rely on very heavily, such that if there was an issue, it would really disrupt, your manufacturing, to focus on those. And then this supply chain mapping, which is also very onerous if you don't have the tools to do it, but more and more there are third-party vendors that provide it. I think some large companies are starting to develop that capability in-house. I saw a very, very interesting demo of a program that Karen does, where they will, you can basically give them the list of your various suppliers, and then they will go through and do the mapping and put together this like beautiful chart of the world that has like every single country diagrammed out with the names of the parties and how risky it is, and goes to find the address and, pulls all the negative news for you. And you can basically get a subscription to that service on a monthly basis. And so I've seen companies basically get that subscription, do the mapping for their high risk supply chains, and then, basically have everyone in their compliance group have like a picture of that up that they can, use and refer to. So that's a lot of work, but I think companies have started to think about needing to do that much work because of things like the UFLPA, where, if you're in a situation where you have a huge shipment that comes in that gets stopped at the border, and you're relying on that, and you very quickly need to prove to Customs and Border Protection that you can get those goods back, you basically have to have done all that work already. So that's I think 2 years ago, I would have said that's like really going above and beyond, but I think more and more that's going to become the norm and what people expect.
Does that kind of supply chain mapping is more focuses on specifically UFLPA, or does it cover more risk other than forced labor risk?
It's a good question. So this particular product is very focused on forced labor issues, but I think they have other ones that are focused on sanctions, for example, or other sort of high risk categories. But really the two that I've seen are mostly focused on forced labor and sanctions.
Thank you very much. And again, this is a question to Mari, but what are the key steps other than risk mapping, like a contractual maybe requirements?
So I think they're all of the ones that you described. Basically, the first is certification, like providing a representation that you're in compliance with whatever the applicable forced labor regulations are. Second, that you have a compliance program in place that's intended to address those issues. A lot of contracts now also include a provision where the third-party supplier is representing that it puts those same requirements on their own suppliers, so that at least one link down the chain, at least you're getting the representation that they are also doing that. And then I think the last one is the audit rights, basically the ability to come in and make sure that the compliance program is working the way it's supposed to.
Thank you very much. So now I'm going to looking ahead and would like to focus on what companies should prioritize over the next few years. So Naoko-san, what's your thought about that?
Okay, so for looking ahead for the next 2-3 years, which is relatively a short time frame. So currently, as I mentioned earlier, the sustainability aspect of the movement is slowing down at this moment. But in my personal opinion, I do not believe that means that ESG is no longer irrelevant or it's not important. Rather, for example, environmental issues are not resolved, right? So I think companies should take more of like a long-term view of all the issues that we're facing. So right now, perhaps the sustainability disclosure obligations have gotten postponed or it's gotten relaxed. So companies might want to use that time that they were able to save, so to speak, to build a more of a robust disclosure-ready, compliance-ready, due diligence-ready system. And I think if you really wanted to utilize AI, that was touched upon in our earlier session, I tell people that, AI is not magic, right? Like you don't like press a button and you don't turn on a switch and everything gets resolved. No, you really need clean data and reliable data in order for AI to actually function. So maybe it might be prudent to start working on sorting out where the data is, or whether it's even digitalized to start with, right? There's still companies who do things on paper, and it's just on paper only, in hard copy only. So,
I still use paper.
So I think maybe that's the initial step that companies can take in the meantime.
That's very helpful. Thank you, Naoko-san. And what about you, Sugie-san?
Yeah, thank you. So I agree with what Naoko-san outlined. And when it comes to third-party management or supply chain risk management, that needs to be approached as a cross-risk initiative that addresses a variety of risks that companies face in its operation. And human rights and forced labor product risks, of course, it is one of the most important risks that companies need to address. But other risks like corruption, greenwashing, product quality fraud, or customs fraud. Apparently, U.S. is now focusing on customs fraud. So, and geopolitical risks. All of these risks are related to supply chain. So, importantly, some of these risks are interconnected. For example, economic security and geopolitical risks related to procurement of some mineral are linked to human rights and forced labor risks, as well as environmental risks. And another example is type of materials procured from a supplier and countries of origin of such materials are related to not only to product quality, but also customs fraud risks. So all of these risks are interconnected. So I would say that it's a time for a Japanese company to consider building up one single platform, a system to address all of these supply chain related risks. So I think many companies manage supply chain risks or third-party risks by having each department have their own data and the information within their department, and key information data related to supply chain are in one department, but it's not another department. So that's not an ideal situation. So it's critical for these departments like legal, compliance, PR, procurement, and business units to collaborate with one another. And it's necessary to have organizational structure and sufficient resources to assess supply chain across the entire company group and address such risks in a consistent manner, so that the companies can utilize its information within the company and build up one single initiative or platform to address all of the supply chain risks that companies face.
Yeah, sure.
If I can chime in a little bit on that. So yes, I think you are, Sugie-san, I think you're totally correct that Japanese companies tend to work in silos. So for example, if it's a human rights issue, that would be handled by the HR department, or if it's a supply chain issue, it would be handled by the procurement department, or if it's a third-party matter, it could be handled by the compliance department or legal. So it's the silo organization, and the data is also siloed. And I think that creates a challenge in the digital world. So back when I was in-house at the company, there were cases where different departments were having different separate contracts with the same supplier, and the terms and conditions differ, and it doesn't really help the company, right? So I think like sorting it out and getting it aligned is very important.
Naoko-san, so do you have a good example of how the company should handle the kind of silo, the tatewari structure?
Yeah, that is a good question, actually. And actually, many Japanese companies are struggling on that part. But I think you can just start with like talking to each other, right? And if there's an issue, if there's a reporting line that reports up to the same executive, maybe that could be sorted out at a higher level and then cascaded down so that a company can take a single approach rather than doing completely different things.
That will be a cross-department initiative. So it is one option to create one meeting body or a platform where all of departments related to compliance join and discuss risks that they're handling. And also it's another option for companies to create a venue where all compliance-related officer and employees can join and discuss. So let me rephrase. So it's an option to create a so-called cross group compliance meeting. Where all of compliance officer within the company group can join and discuss all of the risks they are facing, so that the company as a group can understand what risks they are facing and what kind of information they have, and what kind of information they do not have currently and need to obtain. So that kind of initiatives are the way to address the silo organization in Japanese companies. So I agree with it, Naoko-san.
Thank you very much. And I also agree that the collaboration is very important. And still in relation to the human rights issue, I believe that the determining which department or person is responsible for human rights issue is also very important, because in some cases, when a supplier's issue was raised internally, maybe like a procurement division or a business division, and that were treated by the business division, but because that was not treated as a human rights violation, so like victims were not treated properly or not given the remedy. So I also think it is important to handle the human rights issue as an should be categorized as a human rights issue and then treated properly. So and Mari, going back to my original question, what do you think the company should focus on the next few years?
Human rights issues over the next few years. I guess there's so many to choose from. I guess two in particular that keep me up at night, that I think is probably keeping other people up at night. One is AI, and I think Vincent said earlier, there's a lack of governance around AI, and everyone is racing so fast to implement it, because you don't want to be left behind. But I think it doesn't necessarily leave the time to really reflect on what the impacts are. So, for example, one thing that's come up in the US is the use of algorithmic pricing. And so using AI to set prices for, various industries. And the DOJ antitrust division has been really focused on this and made, a good point when they were looking at algorithmic pricing to say basically, what used to happen in a back room with like people smoking cigars is still going to be illegal if you're using a software program, instead of people sitting around a table talking to each other. And I think that's the part that we're missing because we don't ourselves see exactly how all of these products and services and the technology works. And so making sure that you have governance structures in place to make sure that, there isn't some unanticipated impact as a result of these tools that are being implemented so quickly. And then the second one is the DEI stuff that we've been talking about, just because we have so many different countries that have, different policies in place right now. I'm in a place where we've moved in one direction pretty significantly after having been very pro-DEI for the last few years, and we've already seen a significant change in racial minorities and in women in colleges, in law schools, in law firm promotions, just over the course of a couple of years. Like, if you look at the statistics, it's crazy. Like, we've gone back more than a decade in some of these categories overnight. And so, the concern I have is that we've lost a lot of ground in terms of diversity and our viewpoint on diversity, and that's going to have very long-term impacts. So figuring out the right way to approach those issues over the next few years, given that we have to manage all of these different regimes, I think is a tough one to figure out.
Thank you. So maybe this is a difficult question, but do you think that anti-DEI policy will last the next few years?
I think in the U.S., from a political perspective, I think it will swing a little bit in the other direction. Not to geek out too much on like U.S. politics, and courts, but for those who pay attention to our Supreme Court, like our highest court, that's a lifetime appointment. And so we've had very conservative judges who have been put on the Supreme Court recently who will be there for a very long time. And it is very hard to make huge changes in the law that's applied in the US, like once it goes to the Supreme Court. And so we've had some pretty significant issues go up to the highest court with certain decisions that have been made. And so I think even though politically things will move in one direction, I think the interpretation of the law, we've gone pretty far backwards, and it'll take a lot of time to come back. Again, that's just in the US. In Japan, you're probably fine. So.
Thank you. And sorry, going back to that AI issues. I understand that developer of the AI system is seriously taking care of the AI ethics risk, like biases and privacy issues. But how are the user of the AI system? Does U.S. companies also take care of the?
It's a great question. I think it depends on the company and it depends on the tool. It really runs a range. Like, you'd be surprised at the number of users of algorithmic tools who have no idea what the inputs are and no idea how it works. That happens. And so that's, I think, why it's so important to talk about this governance, even to know what kinds of questions to ask so that you understand how it works. And then even, within the companies that produce these tools, I think there's more of an understanding. But I think sometimes there is a disconnect between the people who, the actual software developers creating something versus, the legal departments who are supposed to oversee it. And so I think that's part of why it's so important for all of us to understand how all of these things work so that we're asking the right questions as we figure this out.
Thank you. Do you have any points to add?
Yeah. AI is an important topic, and AI washing is now one of the important topics that the company needs to address. And I understand that there are a couple of enforcement actions taken by the U.S. government. Like, I think there is one example, like AI lawyer, and if you consult this AI lawyer, you don't have to consult actual lawyer like us. And even if you encounter some traffic accident, you don't have to go to actual lawyers like us and just consult AI lawyer. But it turned out that the AI lawyer does not have that capability like actual lawyer. So that kind of AI washing is the key risk areas that company needs to address. So it's a time to accurately understand what information the AI is gathering and using, and what kind of mechanism or algorithm that the AI is using. So that's so-called AI governance. So that's the one risk area that companies need to pay attention.
Thank you very much. So we are running out of time. So thank you very much all for joining us today. Thank you very much.
Thank you. 皆さん午後いっぱい長時間にわたってお付き合いいただきまして本当にありがとうございました。これにてDay1の方を終わりにしたいと思います。本当にありがとうございました。またおそらくですね来年やると思いますのでぜひまた参加していただければと思います。それでは1日目を終わりにしたいと思います。ありがとうございました。